breaking and entering, drunk and disorderly, law and order. A former prosecutor and a defence barrister, not your usual pairing. And the result? Conversations about crime and punishment that are guaranteed to get you thinking.
Welcome to Justice Matters, a weekly podcast with Lizzie Green and Jay Merchant. Our episodes are every Monday on Apple Podcasts, Spotify, and YouTube. Follow us on Instagram at Justice Matters Pod for clips. Enjoy the episode. This episode deals with sexual assault. It is explicit and could be confronting. Discretion is advised. Good morning, Liz.
Good morning, Jay.
How are you?
I'm very well. How are you?
I'm good, thank you. So today I want to talk about a decision in Canada, and it's a very recent decision, but it's one that's wide-reaching throughout the sport of hockey.
Oh, okay.
Yeah, so we're talking, for Australians, it's ice hockey, but for Canadians, it's just hockey.
Just hockey.
Yeah, and it was the case that 5 hockey players of the World Junior Hockey Team were charged with sexual assault against one female.
I actually thought it was going to be some kind of violence on the ice.
No violence.
They're the hockey cases I've heard of from Canada.
Yeah, well, the skate on the neck.
Yes.
Yeah. So, but no, this here involved a celebration after a victorious tournament in 2018. Rather, it was the World Junior Hockey Championships. Now, they won. Team Canada won. I mean, we're awesome at hockey. That's just hockey and curling.
And
okay?
Modest with it.
Yeah, sorry,
yes.
But no, we're pretty. But what happened is in 2018, so this is June 17, 18, and 19. Okay. So it's summertime.
Yes.
There is a celebration in Canada, in Ontario, and this is in London, Ontario. And so at the celebration, there's alcohol involved, and the fellas are celebrating their victory, and it moves to a bar. Now, this bar is called, Jack's Bar, and it's a pretty happening place.
Sorry, I have 2 quick questions.
Yes.
So, what's the drinking age in Canada?
So it's 18 in Alberta, and Ontario, I want to say it's either 19 or 20. They do things a little differently in Ontario.
And you said it was the junior
team?
So what ages are we talking?
So their ages 18 and upwards. So some were legal and some were not.
Okay.
In terms of drinking.
All right. That's the mum in me.
Yeah. No, that's good. No, some were legal and some were not legal.
But all 18 aged.
Yep, 18 and up. From memory.
Yeah. Okay. Yep. All right. Sorry. Keep going. So Jack's Bar.
So Jack's Bar. Yes. And it was downtown. It was happening. And the players were there and enter in a female. Now, her name has been redacted from the court file. She's known as EM.
Okay.
And it was the case that there was some interactions at Jack's Bar. So I'm just giving you the overview now, and then we'll get into some of the finer details when we get into the court judgment.
Okay. Sorry, I'm just really wanting to get the overview. So we don't know her name, but do we know how old she was?
She is younger. She's old enough to be in the bar.
Okay.
All right.
Yeah, I was wondering. Yep.
She's old enough to be in the bar, and so they're at the bar. They interact with one another, and then her and a fella end up going back to the room. His room. He's a hockey player.
Yep.
And they have sexual relations. And then he sends a text message to others to come in.
No.
If they want to engage in sexual activity.
With her?
Yep. And so this is where things escalated.
I'm sure you're going to tell me, but was she conscious?
Oh, yeah. No, she was conscious.
Was she okay with the others coming in?
Yeah. I mean, we'll get into some of the details now.
Okay. Yes.
So
tell me.
So what transpired is that there was 5 hockey players, and I'll just mention their names now. Michael McLeod was the one that was really into her at the bar.
Who they both went together.
Yes.
Yes.
Into Michael's room. And then there was 4 others. So Carter Hart, Alexander Formenton, Dylan Dubé, and Callan Foote. All right. So they end up in the hotel room, and all of them had sexual relations with her at some point, whether or not it was oral sex or vaginal sex. All of them had.
While they're all in the room together?
And there was instances where she and a player would go to the bathroom and have sex there, and then some in the room.
Okay, so she's definitely not just lying on the bed being used by these.
No.
Okay.
No, absolutely not. All right.
I'm not saying they didn't do anything wrong at this stage.
No.
I don't have all the facts,
That's
but I'm
right.
trying to get a picture of the.
So what happened is that in 2018, after this day, I have to go back because there was police charges and there was not charges, then there was a civil suit type deal.
Okay.
And then there was a recharge. So I have to go back. So 2018, after this happened, the morning of, her mom notices that she's crying. Her mom phones the police. The police do an investigation.
Yep.
The police say no charges will be laid.
Did she know their names? Do you know?
Oh, yeah. Afterwards, they were texting and
okay.
communicating. So it wasn't an identification thing.
Right.
So no charges in 2018. Then we cue forward to 2022, and she commences a civil proceeding.
Okay.
Okay. I should mention that there were statements given in 2018 and statements given in 2022. They didn't match up. They didn't mirror up.
Okay, but so the 2018, was it a she said, they said scenario?
Yes.
And they found in favor of the they said?
Well, the police just had not enough to warrant a charge.
Okay.
In their opinion.
Which is very, sadly, very common in sex offense cases, the he said, she said.
Yeah, and we'll get to some of that when we get to the actual details of the allegations.
All right, so what were the differences between 2018 and 2022 statements?
We'll get to that.
Oh.
So in 2022, there was a civil case. Now, the civil case, there was a settlement, and a substantial settlement.
Right.
And Hockey Canada actually paid it out. All right.
On behalf of all 5?
Well, the 5 players didn't even know that there was a settlement at that time.
What?
Yes. So Hockey Canada in 2022 paid out a substantial amount of money. And so this garnered a lot of questions. Why is it that they're paying this? Where did the funds come out? It was the subject of a parliamentary inquiry.
Really?
Because hockey in Canada is our national sport type deal, money, funds, all of that. And they exercised their discretion to pay out. Then what happened is after all of that transpired, the police reopened an investigation.
Wow.
And charges were laid.
Because of the successful...
Yes.
Because we call it a success if there's a settlement, don't we?
That's right. It was, for her, it was a success at that point.
It's a concession of something.
It would be. And so this garnered wide-ranging support. Now, they recommenced investigations and they recharged them, or they charged them in the first place.
Yes.
And this is some years after. Now, in going through some of the evidence, it was a case that there was discrepancies from the moment they were in Jack's bar until the morning after when she told her mom what happened.
Okay. What sort?
So we'll get to that right now. We'll get right into it.
I was going to say, you're breadcrumbing it.
Yeah. We'll get into it.
On the edge of my seat.
I'm referring to this judgment that was delivered orally and in writing on the 24th of July, 2025. And I should indicate that this judge is a female.
Yes.
Okay. And I had her name, Carochia. Okay. Justice Carochia. And this is the Superior Court of Justice in Ontario.
Okay.
Okay. So we're right up there. Before this matter went to trial, though, there was a jury. The jury was let go. It was mistrial. There was a mistrial.
Oh, okay.
Okay. So at first it was a trial by jury, of course, right?
Yeah.
And there was a mistrial after a jury member communicated with a lawyer. So it was a mistrial.
Oh,
Then there was a note to the judge in the second trial.
from the jury.
Yes.
Yeah.
So this was 3 weeks after hearing evidence
Oh,
in
Lord.
May 2025. So not very long ago.
Yeah, that's very
May
recent.
2025. There was a note to the judge, and the note said that multiple juror members were feeling judged and made fun of by members of the defense.
Really?
Yeah. I've never seen this before.
Sorry, was there 5
Yes.
lawyers?
Yes.
So
There was a team of 5.
but a joint trial for all 5.
Yes.
Yes.
Yeah.
Okay.
And so some of the observations was that they would whisper and turn to each other and laugh at us as jury members, And so the judge had to think, well, how are we going to proceed with this now?
Yes.
Obviously, those identified defense solicitors have an impact on the jury. How could we have a fair trial?
Yes.
And so she was going to grant a mistrial on this for the second mistrial. And then what they did was they came to a consent to have a judge-only trial and to
Sounds
continue.
sensible.
Yeah,
Yeah.
because procedural fairness, trial fairness. So we're at court, and there was CCTV video of Jack's bar.
Yep.
Of them in the bar, of them going to the hotel room. Okay. EM says that effectively she was drunk that night, that she was intoxicated, and that she was so drunk. There were allegations that they were buying her drinks at the bar.
Yep.
And that she was struggling. Now,
with the level of intoxication.
That's right.
Yeah.
Yeah. And the difficulty with that was the CCTV footage outside, like in the actual hotel
Yeah.
bar, and they couldn't see that she was staggering, and so there was some questions on her level just based off of the CCTV footage. Now that's just one aspect, right? We don't have audio, we don't have anything at that point. Go ahead.
Presumably they could see her drinking.
Oh yes, but part of her statements were that they were buying her alcohol, and it was in fact her that was buying alcohol that night. So there was a level of inconsistency there.
Okay, so when you said the difference in statements between 2018 and 2022, you're talking about her statement.
I am.
Right.
I am. Because in 2018, there was no mention of any fear. In fact, we'll get to it. I was just going to go through it, but where she told police she didn't want to press charges. She did not have a level of fear. And in fact, that was only mentioned post 2022.
But is having a feeling of fear relevant to the charge?
It is. It was sexual assault, and in terms of consent. So this matter is a consent case.
Okay. So what's the model of consent, or what's the statutory requirement for consent in this jurisdiction?
I'd like to get to that.
Oh, sorry.
So if I could go through this, and then we can talk consent. All
right. Sorry, I'm getting right ahead of us.
Yeah.
Sorry. I'll just sit here and you tell me.
No, that's all right. So her statement post 2022, or the charges was that she was consuming excessive alcohol, that they were buying her alcohol. Videos said, well, that's not really the case.
Mm-hmm.
She indicated that she felt uncomfortable at the bar despite going up to them and speaking with them. She felt sandwiched in, and that they were grinding, but video shows that she kissed a friend there. She indicated that she felt pressure with Mr. McLeod, and yet the video footage shows that she could have left any time at the bar. So we're still there.
Get a bit uncomfortable.
Yes.
With these ways to refute her story. Like, she could have felt uncomfortable in the room.
Oh, certainly.
And who's going to know that?
Well, we'll get to the room because a lot happened in the room.
All right.
So we're still there. But she talked about being so drunk that she did not have full capacity. But yet at the same token, video footage shows her up at the bar speaking with the bartender and arguing about being shortchanged. So there's evidence that she had some coherent abilities at that stage.
Did they talk to the bartender?
Yes.
Hmm.
So there's video surveillance showing that as they're walking to the hotel, she was walking without difficulty. And these are all findings that the judge found. All right.
Yeah.
So now we're going to get into the allegations. So we're at room 209 at the Delta. And recall that she went with Mr. McLeod.
Yes.
Now, once they arrive at the room, she went into the bathroom, removed her clothes, left him there. She had oral and vaginal sex with Mr. McLeod. And so she returned to the bed naked and laid on top of the counters. From there, what happened is that Mr. McLeod invited teammates from the room, like teammates into the room. And there was all sorts of sexual activities that transpired, whether it was oral or vaginal.
So is she even alleging that first sexual interaction with McLeod was non-consensual?
No, she's not.
Okay,
not at that
so
stage.
he's
Yeah.
charged as a party?
No, there's other sexual acts.
Oh, he's still got involved.
Yeah, that's right.
Okay.
Yeah. She felt like this is part of her evidence that she was feeling really uncomfortable with herself with the others that were in the room. Her complaint was that she was almost like she was being bullied. She felt like there was well over 7 to 8 men in the room. Like there was a few men in the room, right? There was 5 charged. It was a case that she felt things were escalating in terms that there was penises in her face, and she felt like degraded in the sense that she was told to suck it, spit on it, and slap it.
Well, that is degrading.
Yes. And then it was suggested in cross-examination to her that, because that was her testimony, that was her version of events, that it was in fact her that initiated the sexual activities by saying, come on, you've got a girl here, someone have sex with me, you guys are pussies.
Oh, my Lord.
And so she performed sexual activities with the men. And then one individual performed the splits over her face. Put his penis right on my face. And she felt gross and degraded, in her words.
And
Okay.
I don't know what else you're going to tell me, but at this point, I'm feeling very much, whether she was so drunk as to be incapacitated or not, the sheer dynamic of 5 men and 1 woman in a room, like that is a power imbalance in itself.
Certainly in stature as well. I mean, she's a female and they're big hockey players.
Like I'm already feeling so uncomfortable for whatever is going to come out here, because I can't imagine being in that scenario and being brave enough or strong enough to say, everybody out. They're all mates. They're all egging each other on, I assume.
Yeah, I think it's quite clear that from the messages, there was a group chat, there was text messages that were sent saying, hey, anybody want a gummer, come into this room. Anybody want a 3-way, come into this room.
Okay, keep
going.
And
so her main argument in this is that she didn't consent. She was intoxicated. Her words was really drunk and was not having fun and didn't want to stay there, but she felt like she didn't have an option.
So my understanding of Queensland law with intoxication is that, well, traditionally, if you were so drunk that you were incapable of consenting, then intoxication could be a way to negate that you had consented. You had to be so intoxicated you weren't, you had no capacity.
Yeah. But
just being intoxicated, reducing inhibitions, didn't mean your consent was not valid. And so is that similar to Canada? I mean, we've changed it now in Queensland, but that traditionally was what at this time it would have been.
Yeah, no, I mean, she's saying that she didn't give consent. She's saying that she was heavily pressured and was bullied. And she's also saying that alcohol played a factor and that they knew it. So part of what happened during the trial was that it came out that she had a boyfriend at the time. So she felt embarrassed and guilty. And there was actually some videos that were taken that night. Now, these are what the court referred to as consent videos. So at two separate instances, they recorded her.
Oh, Lord.
All right. The first video was at 3:25, and it was a male voice talking to her, and he said, "Hey, are you okay with all of this, right?" And she's like, "Yeah, yes." She's asked again, "You're okay with this?" And she's like, "Yeah, I'm okay with this." She was smiling in the video. The second video was 12 seconds long at 4:28. And it was a male voice said, okay, because it was almost like eliciting consent after the fact.
Yeah.
It was a male voice saying, "Say it." And she said, "Okay, it was all consensual. Are you recording me?" "Yeah." "Okay, good. It was all consensual. What else? I'm so paranoid. Holy, I enjoyed it. I was fine. It was consensual. I am so sober. That's why I can't do this right now." So.
Okay. I find that all very problematic, Jay.
Okay.
They are 100% creating a little insurance policy for themselves with those videos.
Yeah, I don't know. Look, I can't speak to the insurance policy, but where the court said, "I'm not really convinced at that element, but what I am convinced at is her demeanor, her level of discourse, and her conversations when looking at her premise that she was so clearly drunk." And the court looked at it from that angle, not so much as the consent side of things.
Okay, but so you can discount the intoxication. I mean, she might have emphasized that because she had the boyfriend, because she feels embarrassed and guilty, which are, emotions that sex offense victims often feel when they shouldn't. But she might have had to say, "Well, I was so drunk, that's why I did it." But it doesn't mean that she wasn't also intimidated or coerced or forced or in fear.
No, and I agree with you to that extent. But when it comes down to reliability and credibility, if you're shouting from the rooftop that you are so drunk and there is evidence that suggests otherwise, your credibility and reliability are out the window.
Oh, I think it's so hard for successful prosecutions of sex offences anyway. And I think we're making it even harder when we can,
Well, it shouldn't be easy though, as well.
No, I know, but I think the psychology of a sex offence victim is so unique. There's so much that we fully know is tied up in responses and reactions and post-offence feelings and emotions. I think we need to show a little bit of latitude to a victim who may not act as we think they should.
All right. And so I'm going to take you right to that quote I was going to tell you about. We're jumping the gun here.
Sorry.
Because no, it's an important passage, because you're talking about this believability and victims and such, and that's a huge component of these matters. And so the judge talked about this believability and this recognition that there is a movement out there, Me Too and all of that kind of stuff. She said, "Although the slogan, 'Believe the victim,' has been popularized of late, it has no place in a criminal trial. To approach a trial with this assumption that the complainant is automatically telling the truth is equivalent to imposing a presumption of guilt on the person accused of sexual assault, then placing a burden on him to prove his innocence. That is antithetical to the fundamental principles of justice enshrined in our Constitution and to the values underlying free and democratic society." And I think that we need more of that.
No, I don't think it is equivalent to a presumption of guilt. But for so long, for so long. Women, and I'm going to say women, even though men are also victims of sexual assault, I acknowledge that. But women for so long have been left with such injustice when it comes to rape and sex offences because of this issue of consent, because for so long, men can say, so she didn't consent. But look, I believed she was, so let me get off the hook. And it has worked. And so if we are saying, actually, no, we're not going to let that be the prevailing legal principle. If we're going to say, actually, accused, did you ensure that your partner was consenting and put that onus on them, then nothing will change for these victims of these offences because the courts have recognised for years, yep, you didn't consent. We accept you didn't consent, but your accused thought you did, so they're free to go. Like that is not justice.
Yeah, and the difficulty with this matter, I guess, was the fact that there was evidence that suggests that she was the one that initiated what transpired in the room.
Do you mean with the first guy?
With the first, second, third, fourth, and fifth guy.
But is that according to them? Like, do we have independent evidence that it was her instigating it?
But there is none outside of who was in the room. But part of what the court has to work with in these circumstances is the credibility and reliability of those complainants that are giving evidence.
I know.
And that's just the way it works on that. And so if you're giving inconsistent statements, it is doubt in the minds of the judge and the jury. And in this case, it was a judge. So consent is an element of sexual assault. So there was no issue with the touching. There was no issue with the sexual nature. That wasn't the issue. The issue was the absence of consent to sexual touching and subjective. And the issue was whether it was consensual. And the court said the accused are not required to prove that the complainant consented to the sexual contact. The onus is on the Crown to prove beyond reasonable doubt that the accused had sexual contact without her consent. So a very high bar in the sense of when you have a complainant, EM was deemed extremely unreliable and uncredible, if that's not credible, if that's a word. And part of it is because of the varying accounts that she gave, the way she spoke to the players when in cross-examination. It was the case that she said, well, maybe I did say these and maybe I did say that.
Okay. So I'm going to ask an inflammatory question.
Sure.
If they weren't members of the national hockey team, do you think the outcome would have been different? How much leeway did they get for being national heroes?
I think probably, and that was part of the criticism of the judge in the decision, is that perhaps these charges should never have been laid in the first place because of the strength.
She looked at it from the reverse, that they got charged because they were famous.
No, she didn't. But set aside the hockey stuff right now only because I don't think it matters. I don't think it matters because it was maybe it did matter after the civil settlement. But the police in 2018 said that there was not enough to be charged. You have the civil settlement, and then it's revisited, and they commence proceedings.
So, I mean, I guess our similar type of person in Australia are our NRL players or our AFL players. And we've had recent cases of high-profile rape charges against an NRL player by a woman who originally was consenting and then has said she wasn't. You know, it's quite a contentious case.
Yes.
And I think in that case, if he had been an unknown, that case would not have been, decided the way it was. You know, it was all tied with his fame. And so I wonder if that played a part. But then my other part is it's like when we talked about, the Catholic Church making a settlement for sex abuse victims when maybe the priests have not been convicted of things.
Right.
Why are you doing that if it's not a concession of validity in those allegations? So if the Hockey Association are saying, here, you're right, here's some money for you for what you've suffered.
They took a lot of criticism for that, and part of the criticism is they should have never have settled in the first place, and they should have let the players know that they were settling. They didn't.
So they shouldn't have settled because it's seen as an acknowledgement of guilt?
I would say so. I would say so. And without the knowledge of the players.
So then if that is the case, then aren't the police doing the right thing by reinvestigating? If Hockey Canada have said, oh, yeah, there's...
Well, Hockey Canada isn't a police service, and Hockey Canada doesn't have the power to investigate the same as police.
But they didn't... You said they had a reinvestigation.
Yeah, they started up after the settlement because there was public outcry as to why there was a settlement.
I guess I just think the intoxication issue, how can that be such a weighty factor? Like, how can her saying I was drunk, like, I can totally understand why she said she was drunk. Jay, she was having sex with 5 men in one night and she has a boyfriend. She's got to say, I was drunk, because otherwise what?
Does she though? Sorry, but this is part of her downfall, was that this was part of what the court considered could have been was a motive to fabricate. Not only did she have a boyfriend, but she was embarrassed when her mom found her crying the next morning and at what transpired in the room. And so this motive to fabricate or motive to lie, I guess, involved not only that, but also this settlement that rendered her in a financial windfall.
Look, I think I'm going to end up with all of our listeners thinking I am the biggest prude on earth.
No, I don't think so.
Because I keep saying
no.
I'm not making judgments on what people choose to do in bedrooms. But I am sorry. I can't think of many young girls, and I'm assuming she was young, who would be comfortable with that scenario.
Oh, I'm not with you on that.
Really?
Yeah, I'm not with you on that.
5 men?
Yep. She was, the evidence in this matter was quite sexual in terms of her own activity.
That night?
That night, yes.
Yeah, but that's coming from them.
Well, certainly in cross-examination, she couldn't refute a lot of it either.
No, but who's going to be like? It would take a lot to say, actually, guys, no, I don't want to do this. You know what I mean?
But hold on, though. If you're in such fear, walk out the door.
Jay,
leave the hotel room.
Come on, you can't. Like, that's like.
No, it's not. It's not like the Gable Tosti matter where he takes her out to the balcony and shuts the door. She acknowledged in cross-examination that she could have left at any time. She acknowledges that she went from the bathroom back onto the bed naked. Why don't put the clothes back on? She acknowledges that she performed oral sex without anybody holding her head to the penis, and so there's...
But Jay, you don't need to have physical force for there to be a lack of consent.
Oh, absolutely. I get your point on that. But to say that there was fear and that she wasn't, and then to have this transpiring over hours and then her end up leaving with her clothes on in the end anyways, there's so many red flags here.
I feel like... this, and I'm not trying to be rude to you,
but
as a white male,
I am white and male.
You can't even, I don't think, fathom the mind of a young woman in that context.
I get that point, Liz. I get that I don't understand what she went through
or why she might make the decision she made or not made on that night. Like, these are 5 famous big guys. Whether or not she was so drunk to be incapacitated, she'd been drinking. There's no doubt about that.
Oh, yeah, no, she's on the video camera of being drinking.
And so obviously at some point she has alcohol in her system. And if that was a factor in why she went back to the room, so be it, whatever.
Yeah.
But then once she's in this room with these 5 men who are all bros hanging out, putting their penises in her face, she's had sex with one of them. How she, the next step to say, actually, guys, enough, I'm out of here, when they're drunk, I'm assuming.
Oh, there was a level of alcohol, yeah.
And she, possibly unpredictable. Maybe not all of them are nice. Like, we only know what they say their behavior was like. It is a he said, she said, they said.
You're right, but this is a criminal charge, Liz, and...
But judges get it wrong.
This judge did not get it wrong. This judge got it absolutely right. Before I lose my train of thought again, I just want to say there was no evidence that her speech was slurred, that she displayed a sign of intoxication. She was exaggerating in her intoxication. The court said that she was not credible, not reliable, and part of what was given in evidence, and you're absolutely right, it was from those that were in the room, but was the fact that she was asking for it, that she said, if somebody doesn't fuck me right now, I'm leaving.
Sorry, I think every rapist says that they're asking for it. I just want to say that. Why do they get so much credibility attached to what they're saying? They've got 5 of them who are able to corroborate each other. So that's going to give them a degree of credibility which is false because they are all vested in her being found unreliable. So if one of them says, oh, she asked for it, she was initiating it, and the other one goes, yeah, that's exactly right.
Yeah.
Did she say, I initiated it, I asked for it, I was gagging for it?
Oh, look, she was cross-examined to that effect.
And she agreed?
She said a large part she couldn't remember some of it. In fact, part of the court's concerns was that she had to fill gaps with her memory, and she filled gaps with assumptions. And so the court took an issue with that. And on the truth of her evidence and her consistencies versus inconsistencies, the court said that she referred several occasions to her truth as opposed to the truth.
Oh, that's a thing of that generation. I want to tell my truth. It does irk me a little bit when people say that.
So,
yeah. So this was a first finding. Like, do you think that's the end of the matter now?
It is the end of the matter. And I can tell you, because the Crown could have appealed. And they can do that in Canada. Okay. And they made the decision they're not appealing. So I know it took me a while to get through this, and there's more to it. I really encourage everyone to have a look at this judgment because, these are high stakes, and you're going to come back, but it's the victim. But these players, because of this, the inconsistencies in 2018, the change in version between 2018 and 2022 when there was a settlement, and then the subsequent investigation has rendered these 5 players pretty much unemployable now, who were on a trajectory to be in the National Hockey League.
Well, and if they are all innocent, then that is a travesty. But I have so many reservations about this case because it seems to primarily hinge on the fact she said she was drunker than she was.
No, it was more than that. It was the versions of events that she gave that were inconsistent in 2018, 2022, and onwards. The fact that she said that she was fearful in 2022, but yet there was no indication from her version of events, what transpired in the room, that there was actually fear. She could have left at any time. She chose not to.
Okay, so can I just tell you what has come to my mind?
Do it.
And I'm not saying that this judge is the same as the judge I'm about to talk about.
Sure.
But there is a case from Canada.
Yes.
Where a girl was at a party and she went into the bathroom with a guy and she said that he raped her in the bathroom. And it was a jury trial.
Yep.
And the judge intervened during examination of the victim and said, you've said that he pushed your bottom into this. He said you were having sex against the sink. Why didn't you just push your bottom down into the sink so he couldn't penetrate you?
Well, that's an inappropriate question.
Oh my God. The judge was
No,
so
I'm with
wrong
you
the
on
whole
that.
way.
Yeah.
But it's this idea of let's take everything away from an accused. They are the paragons of virtue, and let's make it so difficult for the victim to ever be able to prove. Like, this is sexual offending historically.
Yeah.
Is the lowest of the low rates of conviction because it is so difficult. It's out of sight. There are no independent witnesses.
But what's the solution? Do we get rid of beyond reasonable doubt then and try and introduce a new burden or onus and standard?
We do what we've put in place in Queensland, which is to say that it's only consent if it is free and voluntarily given, that it is affirmative consent, and that there is an onus on an offender to be able to say what they have said or done to ascertain that their victim was consenting. It's not enough to say, oh, I thought they were.
Yeah, but at the same token, where does this end though? Do we, I said in one episode, do we now have to fill out a waiver and have it notarized? Is that what we're getting to? Can we not just have a good night out and engage in sex before we start looking at getting a justice of the peace to sign a stat dec to say we're on board with this?
Okay, I think you're being very facetious.
Sorry.
Because no, you don't need a JP and a waiver.
Well,
but what you do need is to say, are you okay with this?
And that's fine on the night of, until 3 years down the road when we say, nope, didn't do it, didn't consent.
But so what is the difference? But if now we're going to have a jury who has to be convinced beyond reasonable doubt that the accused said, so I then said, are you okay with this? She hadn't said anything for a little while. And I said, is this all okay? They're still assessing the credibility of each of the parties, but it puts this extra step in. You, accused, before you come and say, I believe she was consenting, make sure. Like, why can't people who are having sex make sure that there is agreement? Like, not, oh, well, I just assumed because she was silent. Or the case of Lynette Daly, well, she didn't tell me to stop, so I assumed she was consenting.
Sorry, but that one is different.
It's the same principle. It's the same principle.
Yeah.
That's what they say.
I think it's the heat of the moment type deal, and I think that where we're getting to is this concept that nobody's going to know what it is anymore, and everybody's going to be afraid of having sex with someone.
Well, is that better than having rapes?
Well, alleged rapes. It comes back to this. No, but it comes back to this key paragraph for me, and I'm going to be utilizing this Canadian paragraph in every sexual matter now where there is this issue of believability. It has no place in a criminal trial with the assumption that the complainant is telling the truth, imposing a presumption of guilt on the person accused as opposed to the opposite.
So we will just remain diametrically opposed.
Yeah, and I think we have to. I
just can't get past how difficult it already is for victims and
I would say for the accused as well, in terms of not knowing and having it being able to change like that. So I'm not saying, look, and the issue with this case was that it probably never should have been commenced with in the first place. I'm not saying that I don't believe victims. I'm saying that it's extremely difficult for me to believe a victim when the versions of events change and the circumstances comes out in evidence that just don't match up. I find it very difficult. And I don't know if it serves any female any better if you have changes of events and militia. And I'm not saying, don't get me wrong, I'm not saying that I believe there was a fabrication there, but you would perceive one in certain circumstances. And I think that doesn't do anyone any justice.
Well, I just think we also need to not discount all of the very in-depth research that has been put into victim dynamics and reactions and emotions.
Oh, that
and
part.
Like
I have no idea. Yeah.
So to say, why would she say this? Or why wouldn't she have gone? Or why didn't she just walk out? Like, to me, that is so disparaging of the fact that this kind of scenario, there is no one right way to react. You can't say, well, she didn't do X and Y, so she wasn't a victim. Like, that isn't how it works. And we have gotten to a point of acceptance for DV. We've talked about it with, specifically parents of children who have gone missing or were murdered who don't react the way you expect. They're not grieving publicly, and so maybe they're the guilty party. We've come to this realization that the human psyche is so complex. You cannot expect a cookie cutter reaction.
No,
So
I accept that.
That is where I struggle so much. And if she truly was a victim on that night, I can't imagine the damage of those 5 men taking turns with her. Like, that to me is a life-altering scenario.
Yeah, I would encourage you to have a look at obviously I couldn't, it's a big judgment.
Yeah,
it was
I'll
90
go and
some
read
pages.
it. I'll go and read
I
it.
think you should, because there's a lot more to it. There was a lot more evidence that I didn't get into that deals with credibility and reliability. I want to get to the charges just so that I'm clear for the record. So Carter Hart was charged with an offense, and that has to do with oral sex. So her account of the oral sex is unclear. He said that she was open for it. He asked for a blowy and she agreed. He was found not guilty, and the court found that there was overwhelming evidence to show that she was sexually forward and communicated a willingness. Now, for the offender number 2, or the accused number 2, this was Alexander Formenton. He was charged with vaginal sex in the bathroom. Again, not guilty. Her claim was not accepted. There was evidence from his own statement saying that she was asking for sex, volunteered. In terms of Callan Foote performing the splits over her face while naked, the Crown failed to prove that act constituted a sexual assault. M's testimony about Foote being naked and touching her was unreliable and contradicted by those else in the room.
Sorry, so they're saying that doing that action is not a sexual assault, or that it wasn't credible that he'd done it?
That's right. So it was the case that there was conflicting details of him being naked or not.
Right, because do you ever remember on Big Brother, way back in the day, there was an incident of what they call, I think they say turkey basting, or something, where one of the guys in the Big Brother house whacked his penis and testicles on the face of a female contestant.
Yeah.
And he got removed, and I'm pretty sure there was a charge.
Yeah, no, that would be a charge.
Yeah.
That would be a charge.
But isn't that similar to what those splits things are?
Well, it was over the face, fell naked, and whether or not it hit her in the face, and whether or not he was naked.
Right.
So there wasn't enough evidence to prove it beyond reasonable doubt.
Not that it wouldn't have been an offense.
Oh, it would have. If she didn't want it, and yeah, absolutely.
Okay, right.
Dylan Dubé, slapping her buttocks and receiving oral sex, not guilty. And her account was not fully accepted. It was described as light, playful, and foreplay. Memory was uncertain. Now, Michael McLeod, this is the first.
Mm-hmm.
There was oral sex in the night and vaginal sex in the shower and the bathroom, not guilty. EM's account was confusing and inconsistent. EM allegedly offered blowjobs after being upset nobody wanted full intercourse. There was a count of almost like aiding and abetting because of the other hockey players, the 3-way text offering gummers and stuff over text message.
I'm sorry, what's a gummer?
That's a blowjob, like a gummer.
Oh, gummer. Sorry. So dumb. All right.
No. And the court found that EM was actively seeking sexual contact, contradicting that version of events. So this case really was problematic for the Crown because essentially the court was saying there was not credible evidence in the first place. Why are we here? Why are we back before the courts? There was evidentiary fragility.
Yeah.
There was complainants' credibility issues, and the fact that there was, a mistrial and such. So this court case was one for those that believe the hockey players was a resounding victory. There was protests for the female side of things as well, because certainly her version is that she was sexually assaulted without consent. And whether or not you find beyond reasonable doubt that she was or she wasn't, that's still her belief that she was assaulted multiple times by multiple boys without consent. And so there was protests on that front as well.
I imagine there was. And you know what? Again, if they are truly innocent, then it is really tough for them that their names are out there.
Yeah, I mean, their careers are at stake. They're done. I don't know.
But I also feel a great sense of relief that she has had her anonymity protected, because I imagine the hockey diehard fans would have.
Oh yeah, no, frankly, I mean,
it's not like a normal Joe Smith and Jane Smith case.
This was a scathing indictment on her.
Yeah,
and but also, Liz, not just on her, but also on the decision of the Crown. 2018, they said there wasn't enough evidence. We now have this concept of the civil settlement, and then now we get versions of events, and we recommence proceedings.
So yeah, I suppose if there were those substantial differences between her statement in 2018 and 2022, you question why was it not more vigorous?
Absolutely.
But I think this idea of a settlement being a trigger for a police investigation, I can't be unhappy with that, because I see a settlement payout by an authority like the Catholic Church or the Hockey Canada as an admission of some kind.
By Hockey Canada.
Yeah, by Hockey Canada. Yeah.
The fellas had no idea that this was even.
So they say.
No, they didn't.
Really?
Yeah, they didn't. They had no idea. They found out after the fact.
But so were they still employed by?
It has nothing to do with them.
But were they still employed by Hockey Canada at that point?
Well, they're on different teams. So they're
not all on one team.
Well, for this tournament, they were.
Right.
But they're not, they didn't even
Generally
know each other.
For the league, it's different.
Yeah, they don't know. So, look, part of the criticism is that they made this decision in the first place to settle. And because surely the boys would have said, don't bother, you're not settling this. Or their legal team would have said, you're not settling this.
I do want to read it, but I'm left with, I want to leave with two questions. Firstly, were there differences in what the boys said in 2018 versus what they said in 2022?
I would say there's differences, but I think that's a good thing if you've got this.
So there were still inconsistencies.
Oh, sorry. I thought you meant between the five of them, differences in versions of events between the five of them. No, there wasn't any changes in versions of events.
But also if it had been one guy only in that room and her.
Yes.
And she brought these
McLeod out in the first place.
Yes.
Yep.
And so then you have only her version and his version, not the support of his mates.
Sure.
That could have changed.
That would change things in the sense of you would have less evidence from others, but also
still the issue with the CCTV footage.
Yeah,
and
you've got some credibility and reliability,
but
not to that extent, I don't think, because some of the language she was using was quite
allegedly.
Yeah,
that wasn't on the little recorded snippets. Like that still seems problematic to me as well. Like it seems like they are really. Oh, this could come back to bite us in the ass. Can you say you know?
Yeah, there was a couple witnesses that actually were not the five. So there was a couple witnesses that came in and then left and came in and then left.
Oh, there was an audience as well.
Well, but the audience heard things. Getting better and better. The audience heard things.
Were they also hockey players?
They were.
Oh, as if they're not all going to support each other.
Oh, look.
I find it,
Tell me how good that believability paragraph
from a defense
is.
perspective,
Yeah, love
yes.
it. Absolutely
from a
love
prosecution
it.
perspective, or even from a rights of victims, a victim-centric, like
But you have
I
I know, but with court, you have to divorce yourself of that. And that's why this judgment in my mind is perfect timing, because we need a reminder of that in court, it comes down to the evidence, not whether or not you believe someone.
So are you against all of the reverse onus provisions in our criminal code? Like we recently said for provocation to murder that if you want to rely on that, you have to prove it as an accused. Are you against that sort of reform?
I am more for the presumption of innocence.
Yes.
And it's up to the Crown to prove.
Yes, as a general
Full
principle.
stop.
But we've always had exceptions to the onus of proof. Like we've always had a reverse onus of proof for some things.
Well, there needs to be some evidence of defenses and such, but the onus still goes back on the prosecution.
Look, this case troubles me.
Yeah. Well, why don't
maybe I'll go read it.
Yeah.
Yes, but you've definitely got me thinking. And look, it's hard to know. I don't know. We weren't there.
Yeah, no, and you're right. We weren't there. But I can tell you from a hockey perspective, it's rocked the hockey world back home in so many different ways.
And so am I wrong to say, young people out there maybe don't have 5 or 6 people?
No, we can't say that.
Well, okay.
Well, you can say that. You're a mother, but certainly
I find it can all get quite murky and
well, I think it can, and I think you can put yourself in situations that align itself for problems down the track.
I think that's what I'm trying to say.
Okay.
Not that morally there's anything wrong with it, but in this
you
litigious day and age.
Yeah, well, that's why I was facetious and said, do we need a waiver? Do we need to have it documented and signed?
I know, but I've heard that kind of argument raised to criticize the consent reforms.
No, I wasn't.
Too many times.
Yeah,
I have. So that struck a nerve with me. But I know that at heart you are a very good guy.
Well, I try to be. No, but
so we'll put this aside and we'll be back to being friends.
Yeah. But it's certainly something to think about. As I said, this was a 24 July decision. The Crown came out and said they're not
appealing.
And
which is a statement in itself, isn't it?
It really is. So.
Wow. Okay.
We got there in the end.
Thanks, Jay.
Yeah, thank you.
Interesting.
Thank you for listening to the episode. If you enjoyed it, please rate and review the podcast. If you're interested in clips, check out @Justice Matters Pod on TikTok and Instagram.